So in this video, I'm going to summarise the series of videos that I've made about this statement that it's stated here as a closing submission on behalf of family groups 2 and 3, but is really a statement from lawyers representing those families. This is an enormous document, or a pretty large document of 157 pages, though it seems to be trimmed down because I think it was originally 173. The videos that I've made have mostly focused on the sections that were included in this Times article, which they just lifted from the Thirlwall document, which makes some specific claims about certain infants, and there were also some more general claims that I have analysed in the first video. Originally, I was thinking of joining all those videos together, but that would last 9 hours, and I feel no one would really want to listen to me for 9 hours, realistically. So I thought if I was to do a summary video and then create a playlist of all the videos, that would be a better idea. Someone suggested that. I think it was a good idea. So the playlist for this series is in the description, and this will be a summary of these videos collectively. So I'm going to begin by addressing some general comments that were made by the lawyers in this document. And the first one of these relates to their assertion that there was a conflict of interest in Mr. Simon Driver appearing for the prosecution and being involved with the families. They even concede here that Mr. Simon Driver will appear for the Crown when the case is referred to the Court of Appeal. I don't think it's a case of if, I think it's a case of when. He will be the junior counsel for the Crown. But the Thirlwall lawyers denied that that's a conflict of interest. They claimed that he had no input in the process, but that would I can't confirm or deny that. When they say that he didn't have any impact on the submissions, we have to accept that. We can't disprove it. But I would wonder why he's being employed by the families and doing absolutely nothing, seemingly. That wouldn't seem to make a lot of sense. I mean, God knows lawyers like to make money for doing nothing wherever they possibly can, but that would seem to be a bit of a piss take even for them. Anyway, we'll get into the subject of lawyers later on. The second kind of theme in this document is waffle. So I'll just go over this very briefly. So this is just waffle. This is waffle and irrelevant. This is a disingenuous statement, irrelevant. This is just waffle. This is just waffle. This is waffle that has no merit whatsoever. You get the general idea. The third theme that I have spoken about was the astonishingly poor arguments that were made in this document. For example, at this time, they were obviously trying to prevent the inquiry from being paused for some reason. It clearly, objectively, should have been paused, but wasn't. And they made this comment about the inquiry's gone on for a long time, so there's no point in deferring the findings because the recommendations could encourage a greater focus on patient safety. I've simply described that as possibly the most stupid argument in known human history. Essentially, it's argued here that because the inquiry is almost complete, recommendations which are utterly flawed should be put in place anyway, because this would enhance patient safety in the NHS. I mean, obviously, this is just utterly ridiculous. That is just one of many astonishingly poor arguments. The fourth theme really was high-handed and sanctimonious remarks. So let me return to the topic of lawyers briefly. Now, there are some barristers who I very much respect. They do human rights stuff. They have genuine ethics and morals, and I'm not suggesting that the lawyers that represent the Thirlwall families are bad people or that they're particularly bad for lawyers. I don't know them individually, and I have no idea what their ethics are. But let's be clear on barristers. What barristers do is stand in a room and say things in exchange for money. They don't have to believe those things. They don't have to believe the person they're representing. They certainly don't have to believe the person they're representing is innocent. One example that I always like to cite is that a barrister represented Wayne Couzens, who brutally raped and then murdered Sarah Everard. A barrister represented him in court and tried to reduce his sentence. This is despite the fact he's a serving police officer. It was a completely motiveless. It was a crime without any reasonable motivation. It wasn't a crime of passion. He didn't gain anything from it. He just picked someone up on the street for absolutely no reason and raped her and killed her and dumped her on his land and tried to get away with it and then lied to the police, etc., etc. The court case lasted 5 days because he had to plead guilty because he was caught bang to rights. But still, despite all of this, a barrister got paid to stand in the courtroom and say, yes, Wayne Couzens has done bad shit, but, you should probably reduce his sentence for these reasons. Now, I don't object to that, not at all. I accept that he deserves legal representation. I accept that the lawyer should try as hard as possible. But, let's not get too high-handed and sanctimonious when it comes to... I would say a minority of barristers are in a position to take the moral and ethical high ground. With this in mind, they make this statement about the families, not the families, it's the lawyers representing the families, are concerned by the fact that evidence has been presented on 2 occasions in press conferences, an approach that is entirely unprecedented within the context of an appeal from a criminal conviction. It raises the obvious suspicion that the priority for Letby and his supporters is to generate maximum publicity for a cause, rather than approaching the issues that form the basis for any appeal in a reasoned way. And I have responded by saying the most likely reason for this is simply that the CCRC and appeal system have an abysmal record of responding to appeals. The first instinct of the CCRC and the Court of Appeal is to reject any appeal. This has resulted in several innocent parties having numerous appeals rejected. For example, Andrew Malkinson, who was only exonerated after serving his entire sentence following 3 failed appeals. Even cases that predate the CCRC, such as the Birmingham 6, features appeal being rejected. In the case of Colin Norris, another nurse whose appeal will finally be heard in May despite clear exonerating evidence, his appeal has been delayed, stymied and generally blocked. It is fair to surmise that this is simply due to a lack of public awareness. I will quote the view of Paddy Hill, a member of the Birmingham 6, who sadly died recently. We didn't get our convictions overturned because of the government or the courts. I'll tell you what got our conviction overturned: public outcry. It is understandable that barristers have faith in the legal system. This faith is not necessarily shared by those who don't rely on it for income. And we saw that kind of high-handed attitude, you shouldn't behave in this way, you should behave in the way that we tell you we should. It was repeated in several of the comments. I mean, I find it ridiculous. I just think it, the idea that we should behave, it's a very British idea, isn't it? Or English idea, this is the way you should behave, you shouldn't do this. Trying to get someone out of prison who's got 15 life sentences against them in an extremely intransigent system. It's not like the lawyers don't know that Andrew Malkinson had several appeals rejected. It's common knowledge. So I just found that to be particularly disgusting, to be honest. The fifth theme that I want to talk about from the kind of general themes and the general comments in this document is the case note review. I'll just go over this very quickly. Secondly, case note reviews, as Dr. Horden agreed, are by their nature superficial in approach. This is the comment made by the lawyers. So, of course, literally the entire prosecution case is based on Dr. Evans doing a case note review. So I've simply said we should be clear at this point that the prosecution case is entirely based on a case note review, which one of the prosecuting lawyers has now described as superficial. The sixth theme is a lack of understanding or deliberately disingenuous statements. It's difficult to know which one of these applies. It is possible that in some circumstances the lawyers genuinely don't understand the science. It's also possible they're putting out deliberately disingenuous statements. Very difficult to tell the difference between the two. But in this case, they quote Professor Arthur's and his statement that something is consistent with their embolus and that there was air in the heart and blood vessels. I've simply pointed out that Professor Arthur's never offered explicit support for the hypothesis of embolism at any stage during the trial and was not involved with the creation of this theory. It's really this consistent with comment that, as I've discussed in previous videos, there's a difference between something being consistent with and being diagnostic. In this instance, it's not diagnostic. That's why he's saying it's consistent with. Professor Arthur's is not endorsing the prosecution case here, but they're obviously citing it as very important. Whether they genuinely don't understand that, or whether this is just another specious argument that they're putting in disingenuously, I really don't know. The seventh theme was making disparaging remarks about one of the most respected and credentialed medics in the country, whom unarguably has a world-class level of expertise and experience. This was Professor Nina Modi. I meant to put the statement up here, but I haven't. But essentially, they suggested that she had a conflict of interest because she'd previously been part of the RCPCH, Royal College of Paediatrics and Child Health, and I think this was. I mean, I don't know how hypocritical you might describe this as. Horrend- Exceedingly hypocritical, horrendously hypocritical. I mean, they have a clear conflict of interest because they have someone who's in the prosecution and who's going to be in the prosecution in the future representing the families. You couldn't have a clearer conflict of interest, but they're suggesting that Professor Nina Modi, who's been the head of numerous credential bodies, she's if you had world rank, like tennis-old golf rankings for neonatologists, like the ATP rankings or whatever the golf equivalent is. In Britain, she'd be like number one virtually. She's been the head of all the top neonatology bodies. She's not going to wade into this case and potentially damage her reputation without very good reason. The reason she's done it is because she knows the science is total rubbish, and she knows it's very likely that there's been a miscarriage of justice and there's an innocent person in prison. That's why she's doing it. There's absolutely no chance whatsoever that she should be disrespected for this and that somehow it's a conflict of interest. It's absolutely not a conflict of interest that she was the head of the Royal College of Paediatrics and Child Health. That's in her favour. It absolutely counts against the prosecution case that their experts were so weedy and so inadequate in status compared to the panel that now just completely outranks them. And this comment should just simply never have been made. I mean, it's an embarrassment. The eighth theme was numerous inaccurate comments that were made, including this comment that the families are concerned that the panel appear to be describing issues that have already been ventilated at trial or which were considered as part of the first appeal. This is just simply incorrect, even having seen a small proportion of the overall evidence. We haven't seen the whole appeal, of course. We haven't seen all the documents, the basically 500,000 words of evidence. It's very... even just on the preview document, we already know this statement isn't true, but obviously they're going to be discussing lots of stuff that wasn't quote-unquote ventilated at trial. So that just, again, is a statement that has no merit. So that is a summary of the kind of general themes in the general statement that's made as part of this document. I'll just show you the document again. It's towards the end. I will go through the whole document at some point. I may not do that in quite the way that I've done this because it's 157 pages and I think it'd be a bit relentless if I just went through it over and over and over again. So I might split that up with interspersing it with other videos when I decide to do that. But yeah, that's the end of the first part of the video where we look at the general comments. In the next parts, we're going to look at the infants and the comments that were made about the infants and why these comments are completely flawed. So I'm going to begin by looking at the case of child I. You can see the remarks that were made here in this article in the Times. There are comments about testing indicate the child had never developed the infection. As I noted in the video that I made about child I, they don't actually name the infection. Now, I don't know if that's because the Times journalist didn't know the name of the infection and couldn't find a reference to it, or if it because it does have a very complicated name. But anyway, this is a very poorly founded assertion by the lawyers, and I'll just summarise why it's a very poorly founded assertion. So firstly, eliminating the presence of Stenotrophomonas multifilia requires extremely specific forensic testing. So you can see here, we're walking through the forensic testing that is required. I'm not going to read through all this, I just want you to see it on the screen. I have discussed this in the video on child I. Now there's a lot. It's not just do a simple test, oh, we've ruled that out. It's complicated, it's quite deep. As you'll see from other comments and other points, it's very unlikely that they did that, and there's no indication in the court case they did that. There's been no indication anywhere else that they did that. No reference has ever been made, indeed, to this specific form of testing in court, in Thirlwall documents, in media reporting, or indeed anywhere at all. It's therefore highly doubtful that this testing was done, considering the repeated pattern of failed testing at the Count of Chester that is palpable elsewhere. This was clear in the court case where there are several occasions where they're supposed to have done testing, and it's just not clear whether they carried it out. Seems likely that they never did. And also, of course, there's the insulin tests and the insulin cases where they quite simply did not do the type of testing that is required. So it therefore seems incredibly unlikely that they conducted this very, very complex forensic testing that is required, especially as there is absolutely no reference to it in court. There's absolutely no reference to it anywhere else. So this point I've made here just kind of builds on what I've just said. It's almost certain no testing was done at all. Such issues were repeatedly skipped over in court, and many tests that should have been conducted were never satisfactorily actioned. Even in the case of child O, the infant's mother was critical of the Council of Chester for failing to perform tests related to necrotizing enterocolitis. It should be said that this infant has several symptoms of necrotizing enterocolitis, child O, and yet Dr. Evans still ruled it out completely in court, even though there was no testing. It is known that Pseudomonas aeruginosa was circulating on the unit, and it is also notable that this was completely discounted in court. So this is an article talking about this bacterium that colonised in the taps of the neonatal unit. This is the most kind of well-known reference to it in the Daily Telegraph by Sarah Napton, but it's now been discussed in many different areas, and this was known about at the time. It's not that this wasn't known about. It's in documents from the Thirlwall inquiry. It was discussed at the time on the unit. It's not something that can be denied. It just was completely discounted in the court case, even though it's very significant. It's also known that sepsis was endemic on the neonatal unit at the Council of Chester, and again, this was almost entirely discounted in court and dismissed by Dr. Dowie Evans. This is despite the fact that there were perpetual references to sepsis in Thirlwall documents, so we know now that 9 of the 17 infants have been confirmed as being septic, which is very, very significant and very important. This is a document from the Thirlwall inquiry, but it's actually a review by the Care Quality Commission, and they reference, this is a very weak review, by the way, but they do reference sepsis identification and treatment, finding that not all staff had received sepsis training and processes for the rapid identification and treatment of sepsis were not embedded. Documents we reviewed did not support staff to safely identify sepsis patients. The Trust had developed an action plan to improve this. Now this, as I say, this was a very weak review. They did not do a good job of reviewing the hospital, but they did recognise that sepsis was a problem. What they didn't mention was a number of infants that evidently had sepsis and that were septic at the time. But it was quite clear from the Care Quality Commission that there were problems with sepsis at the Council of Chester. Moving on, it's known that the enterovirus cited by the panel of experts in the case of child G was neither referenced in court nor tested for at any time. The links between Pseudomonas and sepsis are well established, and it is therefore not surprising that infection was endemic on the unit. So I've gone over this in detail in the video on Child I, but there is a well-known link between Pseudomonas and sepsis. Indeed, the bacterium is stated here, is a well-known cause of sepsis, particularly in hospitalised or immunocompromised patients. And then there's some summary and some information about the significance of this. What is particularly important is that such infections are extremely dangerous for neonates, for these very small, prematurely born, vulnerable infants, and they can be fatal in many cases. So I've just done a little summary of this here. Neonatal sepsis, a serious infection in newborns, carries significant dangers, including organ failure, septic shock, and death, particularly in premature and low birth weight infants. It can also lead to long-term developmental problems in some survivors. Early diagnosis and treatment are crucial to improve outcomes. So I should note again that we've just seen, even in the rather weak Care Quality Commission document, we've seen they weren't trained, they couldn't recognise sepsis, they didn't know how to deal with it. So therefore it's hardly surprising that they experienced problems on a unit that has sanitary problems, that's got Pseudomonas circulating, that there's known septic infants, numerous infants suffering from sepsis, to the extent where it's reasonable to describe it as endemic, and then they're not trained to deal with it. So you see all these problems: organ failure, septic shock, neurodevelopmental problems, long-term morbidity, and immediate death. Factors increasing risk: prematurity, low birth weight, underlying medical conditions, maternal infections, delayed treatment. It's a disaster waiting to happen on this unit, and it was just never even, it was just discounted in court. It was just completely discounted. Dr. Evans just decided, oh, there's nothing to do with sepsis. We can just eject that from the discussion completely. It was barely, to use the lawyer's rather pretentious word, it was barely even ventilated in court. It wasn't even discussed. They just denied. Dr. Evans just said, oh, there's no infection. There's no signs of infection. None of these infants collapsed due to infection. I've decided that. Blah blah blah. So it was discounted, and that applies also to Pseudomonas. Pseudomonas is a dangerous bacteria for neonates, particularly in neonatal intensive care units. It's a common cause of infections in this vulnerable population, leading to serious illness and potentially death. Neonates are at higher risk due to their immature immune systems and the multiple invasive procedures they often undergo. It's known why it's dangerous because of immature immune systems, invasive procedures, nosocomial infections, severe clinical outcomes, antibiotic resistance, and it can lead to mortality. And then, there's a problem with sepsis. One of the infants had pneumonia. That can be an issue related to Pseudomonas, meningitis, and necrotizing enterocolitis, which was seemingly present in several infants as well. So this is a complete disaster for the well-being. So we see here strict hand hygiene. This is so important, but it's coming out of the sinks. I mean, the situation couldn't be worse. It's a total disaster for this unit. There's no wonder it was downgraded. It should have been closed immediately. Even Dr. Evans said, when he was interviewed by John Sweeney, this unit should just be closed down immediately. That's crystal clear from the evidence that's available. This is not contested. It's absolutely crystal clear. It's in Thirlwall documents. It's in the medical notes of the infants. It was noted at the unit on the time. It cannot be argued against. And yet in court, Dr. Evans just said, doesn't matter. Doesn't matter. All that matters is that Lucy Letby's injected milk and air into these infants. It is therefore highly doubtful that the presence of Stenotrophomonas multifilia has been meaningfully eliminated, despite the unsupported claims of lawyers. There is certainly no explicit evidence for this, and all available evidence, in fact, points to the literally inverse conclusion. It is therefore likely that the lawyers have simply uncritically repeated the court-stated conclusions of Dr. Evans regarding infection in this case. It should be noted that Dr. Evans ruled out infection in infants where there is undeniable evidence of infection. In fact, Dr. Evans ruled out any and all factors except the supposed malignant behaviour of Lucy Letby. Dr. Evans didn't even know about sewage on the unit when interviewed, despite the fact that this was discussed during the court case. It is also highly likely that the expert panel has accounted for this in their report, which totals 30,000 words. So I'm quite certain that they will have addressed this issue of testing and that they'll make crystal clear exactly why they believe this infection was present. So if we look back at the original comment, we know that it just has absolutely no merit whatsoever. The next infant in the case that this article and the Thirlwall lawyers discuss is child O. The comment here is particularly egregiously ridiculous because they just claim that the cause of death was changed by the panel between December and February because there was a press conference in December and there was a press conference in February, and they claimed the injury was due to an extremely rapid delivery, which is just total, complete and utter rubbish. It completely misrepresents the position of the panel and what was stated in December. If you go back and watch that video, it's just self-evidently ridiculous. But I'll summarise this briefly. So, as I've mentioned in the initial Times article and statements from the Thirlwall lawyers, they allege that the panel changed its mind between its December and February statements. So the first thing to say is the person that was speaking at the press conference in December was Richard Taylor. You can see him saying here, making it very clear that he only read one of the reports in full. That is the report on Baby O, and he qualifies this by saying that he has not seen the medical records himself, but he read the full report. So he's not for 1 second claiming that he's involved in the panel, as I've stated here. He he he's just there to tell people who are in the room what has occurred, and give a summation and answer questions from the journalists. He's never claimed to be part of the panel. He's not part of the panel. There can be no confusion on this whatsoever. He never gave any indication that he'd worked on this. He just read the report and he's there in a kind of public relations or ambassadorial capacity. The second thing is that the two statements that were made in December and February are very consistent with regards to the cause of death, and they're not even significantly different, let alone as the panel supposedly changed its mind. We don't know. We can't possibly know whether the panel changed its mind between December and February because we didn't get to hear from the panel in December. Someone stood up, Dr. Richard Taylor, who's a respected neonatologist. He stood up and gave a summation of it, which was accurate, in fact. However, he wasn't on the panel and he wasn't claiming that these were his conclusions. He was there to give an introductory statement at this press conference. So ultimately, what is being alleged here in this supposedly serious legal document is just absolutely without foundation. Now, an important point is that Dr. Taylor made this comment about a needle being inserted at McBurney's point. So I've used this diagram here to show McBurney's point is on the right-hand side of the abdomen. And then when the final panel report came out, again, we saw that exactly the same comment about a needle perforating the liver here on the right-hand side. It's absolutely consistent with what Dr. Richard Taylor said. Not that it really matters because he's not part of the panel, but it was consistent with that anyway. The statement referenced by the Times article is referring to the cause of a subcapsular hematoma, which has been both cited by several neonatologists as contributing to the cause of death and was even cited by the Countess of Chester itself in internal documents from June 2016. So I haven't dug those up, but I just wanted to show you this briefly, this autopsy report, it's pathology report from Dr. Jane Horden, where she says there was a ruptured subcapsular hematoma of the liver. That is what is being referred to by the panel. That was noted at the time. It's very difficult to say that doesn't exist, although God knows Dr. Evans tried in court. It is likely that the Countess of Chester missed this hematoma because its clinical signs are subtle. So you can see here some information related to the subtle clinical signs of subcapsular hematoma. And let me reiterate yet again, we know this unit was underskilled, we know they were understaffed, we know they're inexperienced, we know they missed things throughout all of these infants, they missed key clinical signs. This is yet another indicator of that. And it's not surprising, it's a difficult job, and I've spoken to nurses that have worked on neonatal units for decades, and one of the things that I was told by more than one nurse is that in neonatology, you encounter things that you haven't encountered before with regularity, because these are vulnerable infants, so they can have all manner of different conditions and different clinical signs and different external, externally observable phenomena on their bodies. So it's not that surprising that some inexperienced nurses and doctors and registrars they didn't have a neonatologist on the unit. For me, you should never be able to handle neonates and call yourself a neonatal unit and you haven't even got a neonatologist. Now, again, I've researched what it takes to become a neonatologist. It's very difficult. It's very competitive and there are not many of them in the country. I was trying to find a kind of definitive figure for how many qualified neonatologists there are in Britain. It's very difficult to find. But I would suggest that it's significantly less than 1,000. It could be roughly the number or even less than the number of Premier League footballers, for example. It's not an easy thing to qualify for. It's very competitive to get on the course, and then it's 3 years, and it's tough to get through the examinations and clinical practice that you have to do at the end. nonetheless, despite the fact that it's difficult, I don't think you should be able to have a neonatal unit without a neonatologist. And I definitely don't think you should be able to have a level 2 neonatal unit without a neonatologist. And I definitely don't think you should be able to have a neonatal unit that was dealing with infants that required level 3 care without a neonatologist. And that's what they had. They had no neonatologist on the unit. They had inexperienced registrars. They had lots of people on secondment, on temporary placements. They had agency staff. They had an inexperienced nursing staff. That's why they missed the clinical signs time and time again throughout the infants discussed in the court case. And this subcapsular hematoma is just one example of that. Dr. Evans asserted that Child O collapsed and died due to the deliberate injection of air, which is scarcely believable considering the demonstrable clinical signs. That really needs no further explanation. Dr. Evans also ruled out the significance of a subcapsular hematoma and even its existence, having changed his view more than once. So again, it seems utterly staggering that Dr. Evans was allowed to just completely rule out the pathology reports where this physically observable phenomenon was mentioned specifically, very explicitly, by Dr. Jane Horden, and then there was a second examination of these infants by Dr. Joan McPartland, and then on top of that we've now got a panel full of neonatologists saying this looks like, subcapsular hematoma is a major contributing factor in the case of Child O, and yet in court Dr. Evans is just able to rule, nothing to do with subcapsular hematoma, it's the injection of air that's critical here. I mean, if you get I would be surprised if you get anyone in the world to agree with the significance, anyone qualified to agree with the significance of air injection, air embolism in this case. It's frankly laughable. Finally, there is a significant link between subcapsular hematomas and sepsis, and Child O was one of 9 infants in the case demonstrating clinical signs of infection. So just a little bit of discussion here of what was said at the time with regard to sepsis. It's clear that sepsis has had a major impact on the outcome of this infant. And then there's a bit of discussion here about the link between subcapsular hematoma and sepsis, risk factors, clinical clues, etc., etc. So that's Child O, and a summary of the evidence and why the statement made by the lawyers and made in the Times article is just complete nonsense. It is worth going to look back at the video. As I say, I've linked to the playlist for all of these videos that go into very great depth regarding all the science for these claims. But that's a full summary of the comments that were made in relation to Child O. So the next infant is Child G. Now, I think the way this is written about in the Times article is quite irresponsible, but I'll read out what it said. Child G was left with quadriplegic cerebral palsy, requiring round-the-clock care after being attacked in September 2015 by Letby, who either overfed the baby or injected air into its stomach. It's one or the other. She either overfed the baby or injected air into its stomach, or a bit of both, or, It's not established meaningfully that this led to the quadriplegic cerebral palsy, and it's also not established that Lucy Letby attacked this infant. So to say it in these definitive terms is just factually incorrect. Anyway, the Letby panel said Child G had an infection, possibly enterovirus, which caused vomiting and a deterioration in its health, and that there was no evidence to support air injection to the stomach or overfeeding. I'm going to begin this summary. This is a particularly egregious case because the prosecution case for this is utterly ridiculous. And Evans and Bohin in court, it was an absolute train wreck. I've gone over that. It took 2.5 hours, and I could have gone on for much longer probably. But my video on that is quite lengthy. I'm going to begin by summarising the background of this infant because it was an extremely vulnerable, extremely premature infant. And it's important to understand that first before we go into the claims made here regarding the panel. So firstly, Child G was an extremely low birth weight infant weighing just 535 grams. So in my earlier video, I demonstrated as just an illustration that it's just over half the weight of a bag of sugar. The gestation of this infant ended highly prematurely, some 4 months before its expected birth. The baby is therefore extremely vulnerable and would not have been expected to survive. Furthermore, it is very likely that the child will suffer with serious disability in the event of survival. So its the best case scenario for this infant was about 30% chance of survival, although some figures say it was significantly lower than that. And the chance of serious disability is 90%. I know it's not nice saying things like that, and I did discuss in the video. I'm not sure what the usual practice is for informing parents of this. I don't know. I don't suppose you're brutally honest with them. I suppose you sugarcoat things, say things to them delicately, and so on. I don't know what the practice is, but I do believe that parents should be informed about these things. I don't think you should skirt around the issue and say, "Oh, the child's doing well," and this child did. This child did do relatively well on the unit, but it's the prognosis for this infant was always terrible. That's undeniable. Child G couldn't even be born, indeed, at the Countess of Chester because they weren't allowed to take her. This led to the infant being transferred back and forth repeatedly between Arrow Park Hospital, which is in Liverpool, and the Countess of Chester. Because of the infant's innate vulnerability, numerous medical staff were not even slightly surprised when this baby deteriorated and collapsed. Indeed, extremely premature babies are inherently vulnerable to deterioration and collapse. Child G had to be ventilated throughout the vast majority of her life. This was literally keeping her alive. Child G was treated for sepsis at Arrow Park Hospital, and numerous medics cited sepsis as being significant in the child's deterioration and struggles. The child experienced multiple collapses and incidences of vomiting. Child G had chronic lung disease from the moment of birth. Child G was also suffering with a catalogue of serious ailments, which led Dr. Shuley to describe her as an infant with a lot of chronic problems. The mother of Child G endured a particularly complicated pregnancy, including one serious incident just days before she gave birth. So that's some background. We're going to be, even in this relatively short summary, we're going to go into some of those issues in slightly more detail, but I'll continue with the summary. The initial clinical picture of Child G meant that the infant was extremely vulnerable. In fact, her chances of survival were quite small, certainly less than 35%, and it was sadly overwhelmingly likely that the child would develop serious disabilities even if she survived. Because Child G was so premature, the infant couldn't even be born at the Countess of Chester Hospital due to restrictions, and thus the birth of the infant took place at Arrow Park Hospital in Liverpool. Partly due to this issue, and also due to deficits of capability at the Countess of Chester, Child G was transferred multiple times during her existence. During the vast majority of her time in hospital, Child G received 100% oxygen ventilation and was kept alive solely by this respiratory support. Child G was notably suffering with sepsis, with indicators for the infection noted at the time, both at the Countess of Chester and Arrow Park Hospital. Child G was indeed treated for sepsis at both institutions. So there's a document here which is a statement made by one of the nurses that was working at the Countess of Chester, and she talks about them discussing sepsis at the time and that there were many clinical signs of sepsis in the case of Child G. That's just one of many documents that point to sepsis. Aside from sepsis, Child G was suffering with several other health problems, including chronic lung disease from birth. The panel of neonatal experts who have assessed Child G described her as suffering with a catalogue of chronic problems. Indeed, you can see in the court reporting from the time, there's a discussion here of some of these problems, including the chronic lung disease just referenced, extreme prematurity, sepsis, active problems including chronic lung disease on CPAP, establishing feeds, and so on. Dr. Evans changed his opinion on Child G literally during the court case, which seems beyond belief, but he actually did that for several infants. When writing to Channel 5 in 2024, Dr. Evans attempted to claim that several events in the case had been destabilised via a combination of milk and air, but this was categorically untrue, and he must surely have been aware of this. So the point here is that he tried to claim, I said that it's a combination of milk and air. I didn't just say it was air. I said it was a combination of milk and air, but in fact he didn't say that at all. This was the only one where he mentioned milk and air. He also mentioned some form of fluid in the case of Child Q, but Lucy Letby was found not guilty on that count. This was the only case where she was found guilty where he mentioned milk and air, but he just essentially lied to Channel 5 about that. I presented the letter in this video, and I think in the video related to this infant, and I think in other videos. So here it is again. none of the babies were killed as a direct result of the injection of air or fluid in air deliberately injected in their stomach. Several were destabilised. But anyway, he just lied, basically. In fact, child G was the only infant in the court case in which allegations of overfeeding with milk were made. This makes very little sense considering that Lucy Letby had supposedly used other methods for every other child in the case, but then suddenly decided to throw milk into the mix with child G. Indeed, it's hard to imagine how she could possibly conceivably have thought that this was a mechanism that could cause collapse. It's probably never been cited in any other court case previously. I'm not aware of any instance in which someone has suggested that an infant has been destabilised by the injection of milk via a syringe. It's a frankly insane allegation that really stands up to no scrutiny whatsoever. Two particular instances of vomiting were cited as significant in the case of child G, but it is undeniable that the child experienced countless incidences of both vomiting and deterioration. So essentially, there were a couple of instances that were cited because Lucy Letby was on duty, but this child was vomiting all the time. And both prosecution witnesses that I'll go on to discuss acknowledge this. It should be emphasised that Lucy Letby was not present for these other incidents and wasn't the designated nurse for child G. In fact, arguably Lucy Letby wasn't really present for one of the incidents included in the court case, as she only raised the alarm as a non-designated nurse when she noticed that there were problems with child G, hardly the act of a guilty person. There was some discussion of a monitor being turned off in court by Lucy Letby, but the evidence in fact does not support this in the slightest, and instead indicates strongly that this was an unintentional medical error by Dr. John Gibbs and Dr. David Harkness. The mechanism of deliberately overfeeding infants with milk is ridiculous for numerous reasons. Overfeeding with milk is logistically unfeasible, particularly when conducted in the manner suggested in court. It would be practically impossible to overfeed an infant with a bottle, and even harder with breastfeeding, let alone via the mechanism suggested in court. And every single person I've spoken to, medics, nurses, they all agree there's just no way that this could happen. Overfeeding an infant with milk is also highly unlikely to be successful in significantly destabilising the infant. It is not really even clear what the allegations are with relation to child G, as the infant recovered from the supposedly significant collapses and was in a perilous state anyway. It is very sad that child G developed cerebral palsy, but according to enormous documented medical statistics, serious disability was bordering on inevitable in this tragic case. Even leaving this aside, the prosecution case for child G required numerous far-fetched assumptions and fabrications, along with several baseless assertions and estimations. It is also clear from even a relatively brief assessment of the evidence provided by Dr. Evans that he made numerous assertions that are categorically incorrect. Healthcare professionals, in my experience, treat this overfeeding of milk hypothesis with universal derision and ridicule. So in the video for child G, I've gone over the court transcripts and various other aspects of the case in considerable depth. And it really is an absolutely ridiculous allegation. And what was said by the Thirlwall lawyers with regard to this case just has absolutely no merit whatsoever. It's staggering that this was ever put in a court case. It's just absolute junk science. And as I said, this cross-examination of the prosecution witnesses in court was an absolute train wreck, where they were backpedaling, saying ridiculous things, changing their views, making assertions that can't possibly be supported. It was just absolutely farcical. And it was indicative and emblematic of the very poor standard of science that is included in this case. So the final infant that I'm going to summarise is child A. And I'm going to go into some of the background on this infant that was also very chronically ill as well. So child A was born at 31 weeks, increasing the risk of complications and mortality. Indeed, the mother of child A wanted the infant to be born elsewhere, presumably because she knew that the infant needed the specialist care that was beyond the capabilities of the neonatal unit at the County Chester. Just to remind you, they didn't have the right to have infants born there that were under the age of 28 weeks. This infant was slightly older than 28 weeks, so it was entitled to be born at County Chester. But the mother didn't want that. She probably realised this hospital isn't particularly great, and it must have been unbelievably traumatic for her to be arguing, presumably to doctors at the time, and to the hospital, look, I want this baby to be born in Liverpool at a proper tertiary unit, a proper established neonatal unit, not one that's going to be downgraded in a few months after it fails repeatedly. And to be refused, and she must have been, oh no, don't worry, we know what we're doing, it'll be absolutely fine. She must have been reassured by the hospital, and then the child passed away very rapidly. I mean, that must have been an awful, painful experience. I can't quite imagine what it would be like, but I mean, it must be a terrible thing to happen, undoubtedly. The prognosis for premature infants has improved, but many still die for what are often unexplained reasons. Child A struggled to breathe adequately from birth and required CPAP ventilation support. There is overwhelming evidence that Child A was suffering with respiratory distress syndrome. Child A also had an increased lactate level, again associated with an increased risk of mortality. There were a catalogue of failings on the unit in relation to Child A, none of which are contested. These include Child A desperately needing surfactant therapy, which is a substance produced by the lungs. You have... I'll try not to explain this in too much depth because it's supposed to be a summary, but some decades ago, it wasn't possible to give surfactant therapy. In the original video related to this infant, I pointed out that John F. Kennedy's child, a child obviously died in 1963, the year that he died, sadly. And this was, I think, 35-week infant. It just simply, often they had respiratory problems, often they had breathing difficulties, and this form of therapy with surfactant is very important. It's made a big difference, the prognosis for neonates, but in this case, this child that had respiratory distress wasn't given surfactant therapy, which is very difficult to understand. I'm not sure why that happened, but it seems to be a major blunder, and it's definitely extremely relevant to the outcome of this infant. Child A went 4 hours without IV fluids, receiving just 2 millilitres of breast milk. Again, an absolutely monumental blunder. Child A was placed under a heat lamp for an extended period, increasing the risk of dehydration and electrolyte disturbances. The long line of Child A was inserted too deeply, but was never corrected. Numerous mistakes were made with line placement, and one catheter was inserted no less than 7 times, risking a catalogue of ailments and problems. So every time you reinsert a catheter, you're introducing the risk of trauma, you're introducing the risk of infection. To do it 7 times is appalling practice, and obviously escalates those risks enormously. Post-mortem examination of Child A did not uncover any evidence of air embolism. This included no presence of frothy blood, considered a classic sign of venous embolism. So in the original video, I've shown the pathology reports and shown details related to that. I'll just very quickly show you that classically frothy blood is observed in the right ventricle of the heart, and air bubbles are also seen in epicardial vessels. Bear in mind, pathologists have examined this infant, 2 pathologists, neither of them observed frothy blood. There's no frothy blood observed. This is explicitly stated by the coroner, and yet Dr. Dowie Evans in court has turned this around to say, oh, it's an air embolism. Skin discoloration observed in Child A points to a cardiorespiratory event. So I'm just showing here, there was a purplish skin discoloration. As you see here, skin discoloration, particularly a bluish or purplish hue, can be a sign of cardiorespiratory event, such as cardiac arrest or a respiratory issue due to a lack of oxygen in the blood. Of course, we know that this infant was struggling in respiratory terms. Somehow, despite all of this, the pathology reports and all known information regarding Child A were inexplicably overturned by Dr. Dowie Evans. Thirlwall lawyers have claimed that comments made by the panel in relation to Child A are known to be incorrect because they were rebuffed by Professor Sally Kinsey in court, and the defence did not contest this. It is true that Professor Sally Kinsey made certain statements in court, but these were not well founded. It is also true that the defence did not specifically challenge these comments in court, but the defence didn't challenge numerous critical statements that are provably incorrect, most notably with regard to the insulin cases. Claims in the case centred around the condition antiphospholipid syndrome, which can cause blood clotting. Clinical notes at the time indicate that both Child A and his twin Child B were born with antiphospholipid syndrome. This was not doubted, challenged, or questioned in any way at the time. Professor Sally Kinsey, for some reason, very flippantly ruled out the possibility of antiphospholipid syndrome in Child A. This is despite the condition being included in the clinical notes of the time. So there's even at a court, this is a court reporting that even Lucy Letby notes that it was discussed that the antiphospholipid syndrome of child A could have been a contributing factor at that time. This assertion from Kinsey also, for some reason, does not take into account the fact that 2 blood tests 12 weeks apart are required to rule out this syndrome. We know for a fact that these were not conducted. By making this assertion, Kinsey is going against the specific guidelines of the British Society for Haematology. So here we have a document, Guidelines on the Investigation and Management of Antiphospholipid Syndrome. It's from the British Society of Haematology. And you see here the diagnosis of APS requires the presence of at least one clinical event, the detection of one or more APL on 2 or more occasions, at least 12 weeks apart. So what occurred in court, where Professor Kinsey made very definitive comments, simply doesn't stand up to any scrutiny, because ultimately, yet again, the testing hadn't been done. So no such statements can be made. I should add, everything points to the fact that there was antiphospholipid syndrome. All the evidence points to the fact that this was present. So why you would then turn that around, that makes even less sense, leaving aside the fact that testing wasn't done. It is important to understand as well that antiphospholipid antibodies can be passed to an infant via the placenta, which occurs with some regularity when the condition is present in the mother. So there's a little overview here of antiphospholipid antibodies can be passed from a mother to a baby through the placenta, leading to a condition known as neonatal antiphospholipid syndrome. This is all explained in much more depth in the full video. The genetic propensity for antiphospholipid syndrome in infants with mothers carrying the condition has been discussed by top geneticist Professor Carola Vinuesa, amongst others. Again, I've got a long statement from her in the video. Indeed, antibodies can be passed on without a positive diagnosis. So again, there's just an overview here. Yes, antiphospholipid antibodies can be passed on even without a formal diagnosis of antiphospholipid syndrome. Of course, in this circumstance, antiphospholipid syndrome, although not clinically diagnosed, was very strongly suspected. When a mother has a diagnosis of antiphospholipid syndrome, it is important for a differential diagnosis of thromboembolism to be conducted, which did not occur in the case of child A. The importance of conditions such as thromboembolism and the likelihood of their involvement in the case of child A was mentioned to me by several medical professionals some months before the panel was even put together. So the panel ultimately made this conclusion that there was thromboembolism in the case of child A. I knew about this months before the panel even came together, because I interviewed people that are qualified and they told me about it. And they cited this as being a very likely diagnosis. Mottling of the skin reported in the case of child A could be related to livedo reticularis. There is considerable evidence which points to this conclusion. Again, I've gone over that in more detail in the video, showing which specific characteristics of this condition could be involved. We don't know if this has been included in the panel report or not, but it is very possible that it could have been. Repeat catheterizations, trauma, and sepsis are all likely to have contributed to the clinical outcome of child A. These issues were noted on the unit at the time. Lucy Letby was not present when the fluids were introduced for child A, which was mentioned in court, and therefore could not be responsible for a supposed air embolism, even though this spurious diagnosis has been completely disproven anyway. In conclusion, the simplistic assertion made by the Thirlwall lawyers and in the Times article was not factually incorrect, but instead simply demonstrates a fundamental lack of understanding and knowledge. So it's actually notable as well, they didn't even mention the condition. They didn't even mention the actual condition, they just said, may have inherited a blood disorder. It's possible that the person that wrote this article, Sean Linton, didn't actually know what the condition was, seeing as he just scooped this out of another document, essentially, without doing any investigation whatsoever or even making a phone call. So I don't know whether he knew that this condition was antiphospholipid syndrome, or he just couldn't write it down because he didn't even know that it was antiphospholipid syndrome. So that concludes this summary of the statement from Thirlwall lawyers. I may revisit the whole statement in the future, but I probably will. But that concludes this section specifically related to the infants that was released just before the first phase of the Thirlwall inquiry was concluded. The recommendation of the Thirlwall inquiry will be released in November, which is frankly a national embarrassment, because these recommendations have no merit whatsoever and will then presumably be implemented across the NHS. So I've been doing this for a few videos now. I initially just intended to respond to the Thirlwall lawyers because I knew someone needed to do it, because what they wrote may sound superficially convincing to some people, but when you actually look at the detail of it, it's farcical. Now that I've done a few videos, which I'd never really done before, I didn't really know what I was capable of doing. I'm not someone that can do. Other people on YouTube have done some fantastic audio-visual stuff. They're proper video editors. They can do effects, bring clips together. I'm not even going to try to do that because other people are doing it better than I could ever do it, and I don't really have the skills or knowledge to do it. I don't really want to learn how to do it. I don't know anything about copyright, and so on. So I wanted to make these videos, and I got encouraged by the first one and the response, so I thought I'd do a few more. And now that I've done a few, I realised that I can do something. There's a niche for me on YouTube, and I can do something that will be informative for people, and that will accompany what already exists. So I'm going to make many more videos. I've done an enormous amount of research on this case. I've been very fortunate to be ably supported by some brilliant researchers. We've probably done research that no one else has done. I think it's unfortunate that at this point in time, I have to be discreet and deal with things delicately because of the Criminal Cases Review Commission application. There's certain things that I would love to do that I can't do currently because I don't want to do anything that's going to be damaging for Lucy's appeal. So I'll get back onto that subject more again in a second. The first thing I'll say with regard to future videos is that there's a lot of stuff that I can do online that I didn't really think about this, but I realised there's stuff that I can do that you can't do in a book because it's either too time consuming, too long, or it just can't be fitted in for reasons of brevity, or it doesn't work well in a written format, and it works better in a visual format. So I did realise there's lots of stuff that I can do that should be interesting for people. So I made a few plans that you can see on the screen here. So the next series I'm going to do is going to be on the insulin cases. I've got tons of court transcripts that are available to me, so I'm going to do some analysis of them. I will probably, some of these series, like I mentioned with the analysis of the Thirlwall document, that I will probably intersperse that with other videos because it's going to be a bit dry to just go through this over and over again. Similarly, I'm going to analyse the Court of Appeal document. Whether I'll do that all in one go, just relentlessly churning out videos on it and then putting them out, I don't know. If I think it's interesting enough for people to watch, then I'll do it, but I'll try and keep things as interesting as possible. But I do want to kind of do forensic analysis of all of these things. So yeah, I'm going to do some more analysis of the Operation Hummingbird itself, and particularly the documentary. I use the term loosely. It's not a documentary, it's a promotional film. Only Cheshire Police would call it a documentary. It's not a documentary. It doesn't meet any of the criteria of a documentary. And then, as I've mentioned previously, I've looked at every single document from the Thirlwall inquiry, so I'll probably do some videos related to that. There's been an unheard live event last night, so I will respond to that when I think it's okay. At the moment, I think that it would probably breach copyright, even though the full version has been posted online on the Unheard website, but they've still got a version on YouTube that is muted for the vast majority of the video, which is fair enough because they've got to make a living, and I don't want to tread on their toes with copyright. But as soon as I can, I will respond to that fully. And then the last thing is eventually I will bring some people onto the channel, some credentialed people for interviews. I've agreed to do this with one person already. I'm sure that I can encourage other people to do it as well. Unfortunately, as I mentioned earlier, I can't do that until the CCRC process is over because I don't want to do anything that's going to be detrimental to Lucy's application, and the CCRC don't look kindly on certain things. I don't want there to be cross-pollination with the appeal team and so forth. So I will do interviews with people. I'm sure they're going to be really interesting, but you have to be a little bit patient for that because it needs to be at the right time. So the last thing is that I promised someone in the comment section that I'd show my dog at some point. So This seemed like an opportune moment, given that I just need to explain that if there's any background noise in this video, it's my dog, because she made this as difficult as possible. I had to re-record an entire section of audio because she was grinding a bone and like bashing it around, and I realised I probably shouldn't have let her have the bone in this room at this time. I thought it would keep her quiet. And she probably jumped up on me about 25 times during the video. So if I sound slightly distracted at any point, that would be why. But, you know, she's worth it. So it doesn't matter. She's the best. Yes, that's all I have to say. Thank you very much for the support for previous videos. If you have any queries, comments, questions, corrections, please let me know in the comments and I'll try to record a new video as soon as possible.